Hello and welcome back to my channel. I just want to say I am extremely frustrated right now with technology. I've been going through a little bit of audio glitches, and today for some reason my entire system won't even recognize my mic or my iPhone rig or anything, and I've been trying for so long. So this video, we're just going to go right into it. No microphone. I'm so sorry. I'm going to work this out for Monday's episode, okay? I'm going to work it out. But there is so much to get into, and I'm crunching for time, you know what I'm saying? But it is Friday, so happy Friday. I can't believe my microphone isn't working, but I'm still here. We're still going to show up because this is so crazy. But anyway, Friday. There is, when I say so much to get into, and today is all going to be with It Ends With Us, because the last 48 hours has been a little Delulu land, and there's been 2 new motions filed today, as of this morning, by the monster of it all, in my opinion, the woman who is centered in between everything, Stehanie motherfucking Jones. And I will say, she kind of drags Jennifer Abel and has a few good points, I'm not going to lie, but the entire thing is very, like Blake, gaslighting, super victim, blame others, and we're going to get really into it. But first, let's talk about some of the headlines that's made its way in the last 48 hours and their responses. So thank you for being here. Again, the audio, I'm so sorry. But if you're ready, I'm ready. You're in frame with Mandy Magnan. Grab your emotional lip gloss. That hasn't changed in this video because the gaslighting is about to begin in 3, 2, 1. My gosh. So Blake Lively's lawyers, the Lively team, has come out and done their first time interview, and now it's huge news. Everyone's talking about Lively's going to testify. Well, duh. That's not big news. Of course she's expected to testify. She's the one claiming all of this stuff happened to her. I don't think this is surprising. I think what this is, you want to know what I think this is? I think what this is after doing their entire PDA press tour to try to convince us that they're good people and they're in love and they're the husband and wife of the year of 2025, that didn't work because it was so fake and it was such BS and blatant horrible PR strategy that now they're like, okay, well, that didn't work, so let's bring it back to the lawsuit. Let's bring it back to Blake will be testifying. Yeah, I figured she would be. Like, what is this? This is ridiculous. But let's get into some of the statements made by the Blake Lively camp, because my gosh, they just don't stop. They don't know when is good enough to just stop. And it's just complete gaslighting because, hello, we've all been following the case, reading every single lawsuit, what is going on here, and I think we all have a pretty good idea of what happened by now. So, oh my gosh, let's just get into it. Blake Lively is preparing to speak out under oath. Duh! In an exclusive interview with People, the actress's attorney, Mike Gottlieb, confirms that Lively, 37, is expected to take the stand in the upcoming trial involving It Ends With Us. Yes, everyone obviously thought that, you know? Yes, Gottlieb said when I was asked if Lively will testify, the ultimate moment for a plaintiff's story to be told is at trial. We expect that to be the case here with Lively, so we would, of course, expect her to be a witness at her trial. Of course she's going to testify. Speculation around Lively's role in the trial surged in late April following her speech at the Time 100 Gala, before revealing on stage that her mother had survived an attack by a work acquaintance who attempted to take her life before Lively was born. The star hinted at the case, saying there was so much to say about the last 2 years of my life. Lively's legal team claims that she also won't be the only one stepping forward. I find this very interesting because no one so far has stepped forward. It seems like everyone that was associated with Blake has taken a huge step back, shall we say, And also, at the time, Gala 100, she didn't just reveal that her mother had survived an attack by a work acquaintance. It was very planted and plotted words in order to suggest the worst crime against a woman, we all know as women, is men, of course, unaliving us, or attacking us, violating us, raping us, to that extent. So she insinuated that it was a man that did this, and why bring up a story that happened over 40 years ago with a work acquaintance to now was absolutely horrendous. We'll say the least about that little speech. There are individuals that were witnesses to or experienced misconduct that is relevant to Miss Lively's claims. Goliath asserts, "We expect their testimony, particularly about what took place on set, will come out through live witness testimony. With discovery underway, both parties will begin questioning those involved. In discovery, they'll have an opportunity to ask Ms. Lively questions," Goliath says. "Likewise, we will have the opportunity to take the depositions of the defendants. Beyond witness accounts, Lively's legal team insists that their case will also rely on evidence. In addition to live testimony, the legal team plans to present documents and statements from producers, Sony Pictures, and other eyewitnesses." Okay, Anyway, it's gonna get interesting, of course. We'll see. I mean, there were tons of eyewitnesses. The cast, the crew, the makeup artists, the security, every single person, hundreds and hundreds and hundreds of people, the other actors involved, et cetera, et cetera, et cetera. Many eyewitnesses, and let's not forget that Justin Baldoni has it on camera. He has all of the footage. Don't you think Brian Freeman knows what he's working with here? Don't you think they've watched all of the takes, all of the B-roll, all of the cameras? And I bet, knowing Justin, after everything that happened, he recorded everything because she was playing games and you could tell from the get-go. Gottlieb argues that public conversation surrounding Lively and Baldoni's legal battle has strayed from the core of the case. "We think that there have been a lot of distractions put up to deflect attention from the retaliation campaign that was launched against her," he claims, "and we expect and hope that in discovery we'll have an opportunity to really focus on what we believe to be the core part of the case, which is that this retaliation campaign was launched against Ms. Lively for her having raised concern about sexual harassment. Whether Reynolds, 48, will testify remains uncertain. He's currently named as a defendant in Baldoni's countersuit, but Lively's team is moving to dismiss those claims. Our belief is that they're frivolous," says Gottlieb, adding that if the claims are dropped, Reynolds may or may not be, in fact, a witness. May or may not be? If your wife was repeatedly sexually harassed during her 16 days on set, which is how many days she was on set for phase 1, would you not want to be a witness to go over how she was coming home, crying, distraught, telling you what happened? Why would you not or not? And if you want to really bring it back to the case, who is deflecting attention? Have you seen your clients in 2025? SNL 50, Time 100, Flying Everywhere, press releases, late night talk shows. Who's deflecting attention? Okay? No, girl. Over the last few months, Baldoni's team has said that they may subpoena major celebrities like Taylor Swift and Hugh Jackman. It's completely unclear what claims or defenses in the case any of these celebrities have any It's completely unclear what claims or defenses in the case any of these celebrities have any relevance to at all, Goliath says. This is a case about what happened to Blake Lively when she raised claims of sexual harassment on the set. It's not a case about how songs were chosen for the movie. It's not a case about fictional Marvel characters and Deadpool. They're not just subpoenaing any star that celebrity Blake Lively was a part of. These people were intentionally involved. Blake Lively has brought up many times Taylor Swift during the entire press tour. They had the meeting of the dragons, which I'll tag that video below because it will spotlight your eyes. But I think if they continually say in the press, oh, retaliation for bringing up sexual harassment, people will start to believe it. But there was no mention of sexual harassment during the entire phase of phase 2 all the way up to the ending of the PR. And even up to that point in January 4th, when she's saying that she brought up concerns of sexual harassment, the very next day, she invited them to her set to her trailer while she was pumping, as well as had her kids on board, as well as still continued to have late night visits with Justin to rehearse such sexual scenes where she was being sexually harassed. Make it make sense, but I think if they continually just keep regurgitating the same things over and over and over, they expect people are going to eat it up. But you know what? I don't eat up puke. Okay? This is what this is. You have to ask the question then, why are these people being subpoenaed, he continues. Do they have any actual relevance to the case at hand? You can't just go around subpoenaing people because they're famous and you think it will generate a bunch of headlines, and the federal courts don't tolerate that kind of behavior. Okay, let's talk about the people that will get subpoenaed. Let's talk about Hugh Jackman. Why was he doing PR for It Ends With Us? Remember that whole cringy video of the sweaters? God, I'm so sorry, that I don't have a microphone. I'm just going to keep saying that because I feel, it's weighing on me. But let's continue. Number 1, Hugh Jackman. Why was Hugh Jackman doing PR for It Ends With Us during the cringy sweater videos, among other things showing up to the release of the party? Still now he's involved. Okay, that's number 1. Number 2, Gigi Hadid. Why was Gigi Hadid there? I would like to know how much money she made from the wardrobe and the costumes and the props from It Ends With Us, because she was at the meeting of the Dragons. Bradley Cooper was at the meeting of the Dragons, yep, and then all of a sudden his name is in the credits. Everything changed after that meeting, right? After they all met up. I'll link the video down below. So why is he being thanked? Oh, why would Ryan Reynolds, just a character from Deadpool, a direct parody of Justin Baldoni, why was his character, who he credited as Gordon Reynolds, also thanked in the credits of It Ends With Us if he had nothing to do with it? Taylor Swift, Blake has used multiple times, and she even was at a meeting, a production meeting that was only supposed to be between Justin and Blake as co-corroborators, co-collaborators on this rooftop scene, and she was at one of the meetings. So why wouldn't she? Why wouldn't all of these people be subpoenaed? Because they were all at the meeting of the Dragons. Blake claims they're all her dragons, and I guarantee they all have something to do with this. 100% I know it to my core. And also on that note, the courts don't appreciate that kind of behavior. What about sham subpoenas? What about silencing content creators? What about doxing people's information? The way Blake Lively gave everyone the information and medical information on Jed Wallace. Do the courts like that? Do the courts like fake lawsuits in order to get a sham subpoena that has nothing to do with sexual harassment to prove a smear campaign about sexual harassment? Guys, you're out of control, okay? We don't expect this case is going to turn into a circus of parroting in every celebrity that might ever had a conversation with Blake Lively or Ryan Reynolds, or in the same way about any famous person who might have had a conversation with Justin Baldoni or Steve Soritz, he says. The case stems from the 2024 filming of It Ends With Us, which debuted in theaters that August. In December, Lively filed a complaint with the California Civil Rights Department after sending it to the New York Times, followed by a lawsuit alleging sexual harassment and a subsequent smear campaign against her. The complaint named Wayfarer Studios and several individuals associated with the production. Baldoni denied the allegations and filed a $400 million countersuit naming Lively, blah, 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 blah. We already know that. And the defamation and civil extortion, Lively's attorneys are calling meritless. That's so crazy, because guess what the rest of the world isn't calling it? Meritless. Yeah. Lively has filed a motion to dismiss Baldoni's countersuit, calling it vengeful, and citing a California law prohibiting retaliation tied to a public disclosure of sexual harassment. Baldoni's attorneys have asked the judge to deny her motions to dismiss I find it just very strange, like their wording as well, to call this like a circus of celebrities when we already know all of the spiderwebs and the intricacies of the case. And these are people's lives, right? Jennifer Abel, Melissa Nathan, Jed Wallace, Justin Baldoni, Emily Baldoni, their children, Steve Soritz, his children, Jamie Heath, his family. These are people's lives that they have tried to ruin and are actively still trying to ruin. So to call it a circus by speaking to the celebrities who were involved, regardless of their celebrity status, is absolutely, to me, again, very distasteful and gaslighting, but I'm not surprised coming from the Lively camp because that's pretty much all they're good for. Now, of course, Brian Freeman responded to that because it's you just heard what was said, right? It is so unbelievable that they're still doing it. But again, if you keep repeating it, you know? So Brian Freeman has responded, and he said, if Blake Lively is really serious about testifying for the world to see, let's live stream it in Madison Square Garden and give the money to the domestic violence survivors. Right. The domestic violence survivors that Blake Lively could not even mention during any of the press tour, except a month later, or at least weeks later, when Sony and Wayfair convinced her to pivot, and then they made, I think she came out and said like one little thing about it. Right, yeah, let's do that. And if you're saying that, you know, she doesn't want the world to see, she doesn't want the world to know, why did she give it to the New York Times? Why did she stand up at Tide 100 and mention it? Yeah, why is she going on late night talk shows? Who's really running the circus? Justin Baldoni, who literally left US and took his family and has not said anything. Not one thing. The Wayfair parties haven't said anything. They haven't been out in the limelight. They haven't done anything. They haven't said anything. They haven't stood up on SNL and made jokes about it. Do you know? So who's running the circus here? Brian Freeman hit back at Goliev's remarks and accused him of trying to deflect from the case. Although obviously uncomfortable for the Lively parties, the truth is not a distraction. Do you hear that? The truth is not a distraction. Freeman told people in a statement, the truth has been clearly shown through unedited receipts, documents, and real-life footage, and more to come. Freeman continued, Blake was the one who brought her high-profile friends into a situation without concern for their own personal or public backlash. As the truth shows, she used her dragons to manipulate Justin at every turn. Freeman's final remarks was a nod to Lively's alleged text messages to Baldoni in which she referred to Swift and Reynolds' dragons. In the alleged text, she compared herself to Khaleesi from Game of Thrones and explained for better or for worse, her dragons protect what she fights for. Who's fighting for you now, Blake? You know? I mean, where are those dragons? In regards to Reynolds' alleged misconduct, Freedom claimed, Ryan's involvement is very well documented, and we continue to discover more intentional misconduct. Was Disney actually complicit in Ryan using shareholder revenues to further a personal grudge? I would be surprised to learn that this type of corporate waste would not lead to much more exposure for those that have been complicit in affecting shareholder revenue. Damn! They're gonna find everything. Marvel, Disney, whatever you guys have, stop fighting. Marvel hiring more defense lawyers so that they don't have to produce records. How is this going to look when Ryan Reynolds and Blake Lively either number one settle and cut that $400 million check? Okay, that would be their best bet at this time. But they are proven to be guilty. And the Wayfair parties come out of this innocent, and everything is proven in court. Of everything that we've seen so far, plus more, because there's video footage, and knowing Brian Freeman, he didn't give us everything. Avi, you gotta keep some aces in the back pocket, you know what I'm saying? In December, Lively filed an 80-page civil rights complaint with the California Civil Rights Department against before officially filing a federal lawsuit just weeks later. The same month, Lively sued Baldoni amidst claims of sexual harassment during production of the motion picture. In her lawsuit, the Gossip Girl alumni accused Baldoni of sexually harassing her in multiple ways, including body shaming her and orchestrating a smear campaign against her to damage her reputation, allegations he denied. Baldoni and his reps have said in response to the lawsuit that Lively twisted the meaning of text messages and misled the public about their interactions while making the motion picture. In her lawsuit, Lively named a number of Baldoni's collaborators, including his company Wayfair Studios, the studio's CEO and financial backer, and PR personnel Melissa Nathan and Jennifer Abel. Yeah, she pretty much named everyone in opposition to her, but still hasn't given zero names of anybody that's going to be testifying or who witnessed it or anything, except, she name dropped Jed Wallace. He didn't have to be in there. And then also Angie Giannotti from Sony, and just a bunch of other stuff, but never once anybody that she ever talked to. But now things are actually getting serious because, as some of you may or may not know, earlier this week, Steve Soritz's house was vandalized by arson. Arson, sounds familiar to, I don't know, sounds like Reynolds, how he committed arson and admitted it, burned down his school or something. Absolutely nuts. But yeah, so Steve Soritz was receiving multiple death threats, his wife also receiving threats. They were going to kidnap their daughter, his daughter receiving threats if they didn't produce $80,000. And then in his guarded community, someone lit the garbage can on fire, caused property damage. Thankfully, nobody was hurt. But in his claim, he brings up Blake Lively. So I think what a better thing to do is, instead of her team coming out and making these absolutely gaslighting, nutty, unprofessional comments, in my opinion, of course, about, subpoenaing celebrities and a circus and this and that. What they should have done is come out and made a statement, first of all, removing them from the arsonist, saying we had no involvement, we never directed them to do this, as well as urging anyone who is on their side or believing them or full on Blake Lively and Ryan Reynolds stands to not choose violence, to not take it this far. Because right now, this guy just said Blake Lively in his little arson attempt and kidnapping attempt for $80K, but then they're out here saying what a circus it is. I just think it's very strange. I don't think they have, I don't believe that they have anything to do with it, although nothing would surprise me. However, I do think that they need to say something about it. Do not ever use violence, okay? As much as we get infuriated, angry, following the case, reporting on the case, like my heart is in this case. I've been following it since the summer when Ryan Reynolds showed up on the red carpet and I didn't see Justin, and Blake said that Ryan wrote the rooftop scene. That day I clocked in for work, okay? So yes, sometimes it is infuriating and you get these gaslit responses and you see them in your face doing all of this crazy, weird, just gross stuff that makes you think that they think that obviously you're stupid, and you get angry and you want to say things and do things and lash out. Violence is never the answer, okay? First of all, we also do need to detach ourselves a little bit. Ryan Reynolds and Blake Lively don't know who we are, and number one, and number two, they don't give a shit, okay? They don't care. I'll just be quite honest. They do not care. So to, in the name of a celebrity, go and do evils like this, really kidnapping, threatening to kidnap someone's daughter, is absolutely unhinged. And whatever side you're on of this case, there is never, ever, ever, ever a need for violence. Okay? These are real people, and that's the statement that the Lively parties should have said. This is the man who was found and charged for the attempted kidnapping, or so he said he was going to kidnap, as well as the arson at Steve Soritz's house. Aragon was charged with 1 count of arson, 6 counts of intimidation, and 1 count of harassment through electronic communications. Lively team is also accused of releasing private health information about Jed Wallace, who works as a fixer for Baldoni. Jed Wallace, 51, says he was dragged into the actress's bitter legal battle with Baldoni after she listed him as a defendant in her administrative complaint filed against her co-star in December. What I find really freaking sad, vindictive, bitter, you're a hypocrite, to be honest, an absolute hypocrite, Blake Lively, is that we know that you were in the courts fighting for attorney eyes only over security issues, over medical bills. And I don't know if you have anything to do with this Aragon. He seems like he's a little bit of a snitchy snitch because he was found like that. So if you are, he will obviously snitch. Like, I mean, come on. Snitch or go to prison, you know? And if you are, my gosh, you are evil. There's no lengths that you will go to. Do I believe currently right now without any evidence that you are? No, but this just goes to show how serious and deranged the internet can be. And your lies are literally harming people. Like leaking Jed Wallace's medical information, you yourself fighting for attorney eyes only for your medical information, but yet releasing other people's. It's absolutely, it's to me a low. It's just nasty. It's nasty. It shows what kind of human being you actually are. Her filing described Wallace as a Texas-based contractor who weaponized a digital army to help create, seed, and promote social media contact, attacking her and defending Baldoni. As part of court filings, Lively's team details that Wallace has suffered life-threatening heart incidents because of the stress caused by attempts to serve him in relation to the case. Documents claim that her persistent efforts to serve him caused his heart condition to flare up and spend some time in the hospital. Ultimately, she did not serve Wallace. And this is very serious because not only Justin Baldoni, I mean, he's away, I think he's in Hawaii, but his entire PR team, as well as Steve Soritz, they are facing horrific death threats, and private health leaks as Blake Lively's war rages on. And at this point, just cut it out. Like, oh my gosh, if it turns out that this entire time we were all right about you and you are lying, and it's proven that you're lying, and the damage that you have done to these people, that is unforgivable. Because at any point you could have settled, given up, apologized, told the truth, got help, but you kept going. Okay? And it's gross. It's just so nasty. And currently right now, I think because no one is believing you because we haven't seen any proof. Zero evidence. Not one thing. In fact, I would even say, Blake Lively, that in your own lawsuit, the times that you say that you confided in other actresses, you were their boss because you were a producer also, so that's weird. It looks to me like what you were trying to do is the same thing you did on Gossip Girl to Penn Badgley. You're a toxic coworker to have on set when you don't get your way, and everyone knows by being in a work environment, it only takes one person. What you did to Penn Badgley, because you didn't really like him that much, you thought he was kind of weird and you didn't want him around, is you went to all of the cast and tried to turn them on him. You've admitted it. You admitted doing that. Can you imagine showing up to work and someone who is supposed to be your love interest, I mean your bestie, let's say your trainee if it's not on set, but you show up to set knowing that the star show, the best performer, is going around your back, targeting you and trying to get everyone not to like you, and you try to do the same thing on It Ends With Us, guaranteed, because your text in your own lawsuit to me prove it. Okay? You said that you texted one of their friends. They're both friends between Justin and Blake. A friend. We all think it's Liz Plank, obviously. And you were calling them creeps and clowns. What? In none of the texts that Justin has ever sent regarding Blake Lively during even the smear campaign has he ever fully insulted her. He said, I know what kind of woman she is. She always needs to be right. I don't think she's going to stop. And you're calling them clowns and creeps during production. In another text you said where you were talking to another actress on set, you texted her saying, I'm dreading going back to work. Ugh, I can't believe I have to go back. What kind of attitude and vibe is that? It's the exact same thing. You were trying to separate everyone and make them hate Justin Baldoni and adore you like you're the best, you're the powerful one. In another statement, you said in your own lawsuit that you went up to another female co-star, the same co-star you were texting, and said, don't worry, I talked to them. They're not going to touch you anymore. You don't need to hug them. Implying that hugs is some form of repeated sexual harassment on set. Meanwhile, there's videos of you, Blake, getting out of your car, running up and openly hugging. So if someone doesn't want to hug, that is a personal boundary that that person can have, and I'm sure if they have communicated that boundary with Wayfair, they wouldn't have been hugged anymore. But for you to take their boundary and twist it on its head to make it seem like it's sexual harassment is freaking bleeping crazy. Just an example of some of the death threats. Why can't I say death threats today? Just an example of some of the death threats. Jennifer, they did give some threats that have been sent to Melissa Nathan, Jennifer Abel. I mean, all of them. I mean, including their children, their addresses, their school addresses. It is frightening the lengths that these people are going to go through to defend Blake Lively and Ryan Reynolds. And it even says that they found out these people's addresses, the Wayfair party's addresses, because Blake Lively had them in the lawsuits. In some of their lawsuits, they doxed their personal information like addresses, medical records, etc., etc. Evil. But this is just one of them as an example because I find it totally horrendous. But it says, you're literally one of the evilest people in the world, terrorist evil. Your Blake Lively campaign is on par with something you'd expect from Trump and his disciples. It's not even spelled right, but I realize that being called a public relations terrorist is probably sending you into a mild something. It's not meant as a compliment. One can only hope you have the worst Christmas and that Hollywood realize that you are the Hitler of publicists. Your response was an insult to any person with any ounce of intelligence and the equivalent of a junior PR student's ramblings. It was the joking of people, and you did nothing one would expect from a matter in this business. The only hope is that studios treat you like the scum-flushing vile creature that you are and cancel you. Now, this was just one of many, and this isn't even the most frightening messages that they've received. And I mean, I sit up here and talk about how I think Ryan Reynolds and Blake Lively truly are evil. They need help. They really need God, maybe, or something. I mean, they are truly, truly evil, and they've been evil for decades, but no one shined a spotlight on the darkness. I can sit up here right away and tell you that I think Stehanie motherfucking Jones is a horrendous boss. I think she is just a nasty human being, in my opinion. But would I ever go as far as sending them threatening messages, sending them even an email about my opinion, doing anything, going as far as threatening to kidnap their children? No. At all. That is diabolical. That is unhinged behavior. This is why mental health matters and people need to examine the internet, okay? Also, I just want to say on this matter that I didn't actually, at first I was like, no way someone or groups of people or many people believe Blake Lively enough after everything, after doing their critical thinking, reading the lawsuits, seeing what has actually happened, that they still side with Blake Lively so strongly as to send these messages, these emails, threaten to kidnap, etc., etc., etc. I was like, no way. Because, I mean, it's right here, right? I mean, read the freaking lawsuits. Just read the timeline of relevant events only if you don't have enough time or the attention span to really get into all of it, right? I was like, no way. No way, Jose. That is not real. It cannot be. Right? I was like, no way. But then last night during some research that I was doing on my deep dive about Ryan Reynolds, I found Reddit links, like Reddit pages, all about pro Blake Lively. And I mean thousands of people siding with Blake. And I just couldn't comprehend. And I read a lot of the Reddit threads, and I was like, what? And it's all based because she is a woman, most of it from what I read. Is they're eating it up. They are eating it. They are the ones that are eating up this stuff that she was definitely sexually harassed. She brought up the sexual harassment, and they started a smear campaign because she brought up the sexual harassment. If y'all can form me that timeline of exactly those events, I would love to see it because there's no evidence of any of it. But yeah, there are some people out there, thousands of people out there that are diehard stands for Blake Lively and Ryan Reynolds, and truly, I think they truly believe that either by sheer ignorance or because of their belief system or whatever, they do believe. And at length, some of the things I read on those subreddits, unhinged, uneducated, and just truly, I don't know, in my opinion, very wrong. Also, I just want to talk a little bit about this article that was done in the Hollywood Reporter from Jessica Scharzer. She's a creator on the film, I guess a writer. It's kind of interesting. There's a lot of little Easter eggs in there that she gives away, clearly not on purpose, but I'm not going to read through the entire thing because I don't think it really deserves that. But what I will say is, Brian Freeman, you need to get your hands on the original script of Another Simple Favor, because if you don't know yet, Miss Blake Lively has a line in that movie that says, "I'm going to sue you into oblivion." Now, we all know oblivion stems from first Jane the Virgin, number 2, Brian Freeman on the Megyn Kelly show, and now Blake Lively saying it in Another Simple Favor with her back turned. Could she have been mic'd and it was an original line? Yes. Could it have been a voiceover, an ADR, which she did in post-production? Also yes. Also in that scene, in this article, Jessica here talks about how Blake did have full creative control over the wardrobe, took over wardrobe, she rewrote scenes, she's super funny, so it was okay that she rewrote a bunch of lines, and also that she had the script ahead of time and approved it. Therefore, while she was on the set of It Ends With Us, she already had the script because she went from that set to this set immediately. So she already had the set. And if you don't know what the big plot twist is in Another Simple Favor, Blake Lively has a triplet. And that triplet ends up seducing Blake Lively's character, and they have like a whole thing. Blake Lively with Blake Lively, which I guess is also not done well because they're not even wearing the same earrings and the continuity is way off, but that's a whole other thing. But yeah, so that's really weird because here she is on the set of It Ends With Us, you know, not even being able to, I guess, talk about porn addiction or sex, or not even talk to Justin about really anything. Dads, parents, nothing. Everything was sexual harassment, okay? Lingering too long on a kiss, doing too many takes of a scene, which is like not an actor's job to call how many takes are on. But you get what I'm saying? You can't talk about anything to her because she's so innocent and such a prune. And if you say anything to Miss Blake Lively, Shroud Wife 2025, her panties are going to be in a big bunch, right? Can't even if it has to do with Ryle, the character, even if it had to do with the creation of the movie and the backstory of the movie, that was sexual harassment. However, she's reading a script and approving a script where all of this other stuff happens. And then adding a line, possibly, of "I'm going to see you into oblivion." And if that was added and you are doing exactly what your husband did in Deadpool and Wolverine and you are now doing it in Another Simple Favor, your case is done because who jokes about that kind of stuff? Who literally, after being sexually harassed and filing a lawsuit and claiming all of this emotional distress and how this ruined your life, is making jokes about it? Nah. No. Come on. That's just so crazy. Okay, get ready because we are going into it. Here we go. This is the first one that was filed, or the second one. I'm not sure what order, but they were both filed today by Stehanie Jones. This is the Jennifer Abel one. So Jennifer Abel, Melissa Nathan, Justin Baldoni, Wayfarer Studios. Plaintiff's memorandum of law in support of their motion to dismiss Wayfarer Studios LLC. So this is for the Wayfarer Studios one. There are two pending right now against Stehanie motherfucking Jones, one from Jennifer Abel directly, and then also one from the Wayfarer. So this is the Wayfarer one. I have already read them. If you're ready to get gaslit into the next universe, buckle up because it's very interesting what they're claiming here. That was so weird. Okay, the preliminary statements. Wayfarer's amended counterclaims are, like their predecessors, devoid any... Oh, dang. Wayfarer's amended counterclaims are, like their predecessors, devoid of any footing in law or reality and serve only as a transparent vehicle to vent Wayfarer's anger over the lawful exposure of its co-founder Justin Baldoni's sexual harassment of co-star Blake Lively and Wayfarer's retaliatory vindictive smear campaign that followed. I rate not at Baldoni's wrongdoing, but that it was widely covered in the press. Wayfarer now seeks to punish Jones' works and its founder, Stehanie Jones, masking lawful process with defamatory cries of leaks. These were no leaks, and Wayfarer is not a victim. Instead, it was a principal actor not only in the Lively campaign, but also in a covert, calculated scheme to sabotage Jones' works from within and flout scheme to sabotage Jones' works from within and flout irrefutable, plain contractual commitments. Wayfarer's amended counterclaims fare no better than their first attempt, falling far short of stating any viable claim for relief. Wayfarer's breach of contract counterclaim primarily rests on specious allegations that Jones and Jones Works improperly divulged confidential information. This fails on numerous fronts. First, confidential information, as defined in the agreement, excludes information which is or later becomes publicly available through no wrongful act of a company. That is precisely what happened here. Information was produced and made public pursuant to a lawful subpoena, which, after months of cries of phantom subpoenas, even Wayfarer finally accepts. Yeah, because, oh my gosh, it's not the fact that there was a lawsuit with a subpoena. The subpoena was a sham because it had nothing to do with you, Stehanie Jones. Does 1 through 10, and it was for employees and people who had contractual obligations to Lively and Reynolds, which you didn't, right? It was a ploy. It was a joke. Everyone knows that. It was the shadiest thing that have come out so far about this lawsuit. Second, Wayfarer alleges that the information produced was Abel's private communications, not Wayfarer's confidential information, which is self-defeating of Wayfarer's breach of contract claim. Third, Wayfarer's false allegations are hopelessly vague, failing to identify and purported confidential information with any specificity. The lack of detail is for good reason, as under no construction could information exposing a vindictive sexual harassment and retaliation conspiracy constitute Wayfarer information subject to protection. Finally, Wayfarer's amended counterclaims attempt to yield the confidential provision of the services agreement between Jones Works and Wayfarer to suppress disclosures concerning Lively's harassment at the hands of Wayfarer's co-founder, as well as the company's own role in the ensuing retaliation campaign, while punishing Jones and Jones Works for cooperating with the legal process that brought those facts to light. So basically, she just, in both lawsuits, literally says that she was just following the subpoena. She did nothing wrong. She's not at fault. Okay? Now they're okay to talk about the subpoena. It's unbelievable. This effort is squarely prohibited by the Federal Speak Out Act, which precludes enforcement or pre-dispute non-disclosure clauses in matters involving sexual harassment and retaliation, and accordingly renders the confidentiality clause of the Wayfair Agreement unenforceable. Wayfair also alleges that Jones failed to render services in a professional manner or in accordance with Wayfair's goals. Not so. The amended counterclaims themselves reveal that Jones worked tirelessly on Baldoni and Wayfair's behalf to pursue a positive agenda in seeking to counteract negative press about Baldoni, press that stemmed from Baldoni's own wrongdoing. So she's really on board here that he did all of this stuff to Blake Lively on the set. But what's so crazy is that if they hadn't left Jones' works, she would still be defending them. She would be in this lawsuit. Well, it probably would have never happened as a lawsuit because they wouldn't have got the text messages. So it is a super vindictive thing for Stehanie Jones, because had they not left Jones' works, they would all still be a team. And Leslie Sloan wouldn't have never got the text messages that they cherry-picked in order to try to tell a story. Wayfair also alleges that Jones failed to render services in a professional manner in accordance with Wayfair's goals. Not so. The amended counterclaims themselves reveal that Jones worked tirelessly on Baldoni and Wayfair's behalf to pursue a positive agenda in seeking to counteract negative press about Baldoni. Press that stemmed from Baldoni's own wrongdoing. Wayfair's breach of contract claim also fails because it unilaterally and wrongfully purported to terminate the very agreement it now accuses Jones and Jones Works of breaching. In August 2024, months before the agreement's end date, Wayfair purported, oh gosh, let's not start already, to cut ties with Jones Works without providing the requisite notice or opportunity to cure, and then ceased paying it monthly fees to Jones Works in blatant violation of its contractual obligations. Its counterclaim hinges on the legally untenable theory that its own non-performance was excused, despite offering no factual allegations establishing a material breach by Jones or Jones Works that could justify termination or non-performance. In short, Wayfair has failed to plausibly plead a breach of contract claim to withstand Rule 12b-6 motion to dismiss. Wayfair's implied covenant of good faith and fair dealings counterclaim fares no better. Wayfair has not alleged that the agreement was not performed in good faith. Instead, Wayfair has alleged a misguided breach of contract claim, which fails for the parade of reasons set forth above and herein. Finally, Wayfair's new defamation counterclaim collapses under minimal scrutiny. For one, Wayfair's amended counterclaims are bereft of any allegations that the allegedly defamatory statement regarding a smear campaign to destroy Lively's reputation as retaliation for Lively's purported complaints about sexual harassment on set is false. In fact, the amended counterclaims are rife with allegations that confirm the truth of the statement and falsify aside the purported statements that Wayfair's crusade against Lively was a smear campaign is a quintessential protected opinion, protected under well-established First Amendment principles. Moreover, as a public figure, Wayfair was required to allege that the statement was made with actual malice. It does not provide yet another basis for dismissal, but also fails as a matter of law and is so baseless that it warrants an award of attorney fees under New York's anti-SLAPP statute. Wayfair's amended counterclaims are not just meritless, they are retaliatory. Oh my gosh, they're really going to go there with the same thing, that they are defending themselves. Blake Lively's camp already tried this one, that when they were defending themselves, they're yet again attacking Blake Lively. Come on. Wayfair's amended counterclaims are not just meritless, they are retaliatory. They are yet another effort at a smokescreen transparently leveraged to shift the limelight from Wayfair and its founders' bad acts. Wayfair breached its contract with Jones Works and participated in a campaign to take down Jones and the business she spent years building. Wayfair must be held to account, absent the distraction of faulty amended counterclaims. Then they kind of go into the background of Jones Works, etc. May 2020, Wayfair agreed to pay Jones Works $20,000 per month in exchange for Jones Works PR and communication services and an additional $5,000 per month for services provided to Baldoni. We already know in the last videos I did the math, and they've given this girl already almost $1 million. Water break. The agreement states that Jones Works will be Wayfair's exclusive public relations counsel to provide strategic communication services, including positioning and utilizing Wayfair Studios' key executives as thought leaders and change. Remember that, thought leaders. I think that comes up again. I just realized. Thought leaders and change agents in the film and television industry. The agreement further sets forth that Jones Works shall provide the service in a professional manner and in accordance with the goals mutually established by Wayfair and Jones Works. Then they have the agreement. The agreement does not require that Jones Works notify Wayfair in the event it receives a subpoena compelling the disclosure of information potentially relating to Wayfair. So she's pretty much just saying, pleading stupid and ignorance, really. Well, how was I supposed to know that? I should tell them that they have a subpoena. What? That's your defense? I mean, maybe by law you can get away with it, but morality-wise, you're done. That is so shady. Of course you should tell them. Duh. That's just, I think that is just, that's your argument. Is like, well, it's not in the contract, I have to tell them about subpoenas. Jones Works employee Jennifer Abel was its point person on the Wayfair account, entrusted with the role due to her seniority and experience. Although not running point, Jones regularly participated in meetings, calls, and written correspondence. As Baldoni's harassing misdeeds began to appear in the media, Wayfair and Baldoni engaged crisis PR expert Melissa Nathan. Jones advocated positivity. That's not what your messages say, girl. However, unbeknownst to her, Abel and Nathan were running a shadow campaign for Wayfair and Baldoni to destroy and bury Lively. The same stuff, the same lines, to destroy and bury. On August 8th, 2024, a Daily Mail reporter told Abel and Jones that she was working on a story surrounding the recent rumors that there was a feud between Ends with Us co-stars Blake Lively and Justin Baldoni. She's basically saying that she never did shit. She didn't do it. And I also, in the red, there's spelling mistakes just, like, get to me, especially when they're in this form. Like, there's no reason that they should have read this over and have this spelling mistake. Having returned a miscalled believed to be, a miscall believed to be. I know it's just a small thing, but when you're paying these lawyers, what, 10 grand an hour maybe? You know, you're going to have spelling mistakes. Jones never called or connected with the Daily Mail reporter. Naturally, Jones' press strategy, focusing on promoting positive narratives, was not aligned with Wayfair's secret agenda for taking down Lively. This was objectively false, as Jones confirmed that at the time to Wayfair's president, Tara Hanks, she never leaked any information about Baldoni or Wayfair to the Daily Mail or any other outlet. Nonetheless, falsely accused and seeking to squash the perpetuation of false narratives, Jones naturally contacted Sony to inform them that she did not do so. Jones continued to advise Wayfair on a positive approach in navigating the PR fallout, particularly given that, in her view, Baldoni was not being represented in these stories, so they had to fight for every story. Jones reiterated that her goal was to help Baldoni and Wayfair. How can you say that your goal was to help Baldoni and Wayfair and then literally say that, how am I supposed to tell them that we got subpoenaed for their own phone records? Come on. Wayfair, whose circles held Lively in deep disdain and to a certain extent regarded her self-immolation with a degree of schadenfreude, adopt the opposite convert strategy to smear Lively. Heath, having signed on to this strategy, rejected Jones's recommendation and emailed Jones instructing that she not respond, contact, or do anything as it pertains to Justin or Wayfair, all while keeping Jones in the dark. It's just baffling to me that she can say that their thing doesn't make sense, but then she's going back and forth. She was part of the meetings and communications, then she was in the dark, so I don't know. On August 21st, 2024, Jones terminated Abel. In August 2024, Wayfair purported to unilaterally terminate the agreement and within its clause requiring that matters be arbitrated, advising Jonesworks that the termination would be effective as of the end of August. Wayfair's notice to Jonesworks did not provide a legitimate reason for terminating the agreement or cite to any provision of the agreement that was perpetually breached by Jonesworks in justifying the termination. They did not because they could not. By September 2024, Wayfair had engaged Abel's new firm to provide PR services. Then it says in red, I put it in red, pursuant to subpoena, Jonesworks produced documents. But it's the subpoena was from a lawsuit that had nothing to do with, with Jonesworks. That's why it's so, still I think it's very shammy, and I don't know if the courts are really going to like that. Like, I'm sure the judge right now is like, whoa, what is going on here? A complaint must, but we have to understand also that we're dealing with a movie that made over $300 million. So it's a lot of money that these people were fighting over, and getting for Stehanie Jones getting paid $20,000 a month, and Wayfair being their smallest client. I mean, imagine what she gets paid by The Rock or Jeff Bezos when they were her clients. Now they go into the legal standard, saying a complaint must allege facts which, when taken as true, contain sufficient matter to state a claim to relief that is plausible on its face. Furthermore, allegations that are nonsensical as well as assertions that are ominous critical facts do not have to be accepted on a motion to dismiss. Wayfair's breach of contract counterclaim should be dismissed for failure to state a claim. Wayfair fails to plausibly allege plaintiffs breached the agreement. Wayfair's first breach of contractual counterclaim asserting that plaintiffs breached the Wayfair agreement's confidentiality provision fails because it does not specify how Jones or Jonesworks breached the parties' agreement. To sufficiently state a breach of contract claim, a plaintiff must allege both the provisions of the contract that were breached and how those provisions were violated. Wayfair fails on both fronts. In its amended counterclaim, Wayfair includes several new paragraphs outlining a purported scheme through which Jones and Jonesworks somehow improperly disclosed Wayfair's confidential information to Sloan Lively's husband, Ryan Reynolds, and eventually media outlets, including the New York Times, via a lawful subpoena. Notice how they're putting lawful up there? These are hollow accusations lacking in any support whatsoever. For one, Wayfair never states what exactly this purportedly confidential information was. This alone is fatal to its breach of contract claim. Wayfair makes no serious attempt to argue that Jones acted improperly in responding to a subpoena and producing documents. That silence is telling, as not only did Jones act properly, but she was legally obligated to comply. Wayfair's lone assertion of impropriety is that Jonesworks did not provide notice of the subpoena to Wayfair or its representatives. But the agreement contains no such obligations. Having never negotiated nor agreed to such a provision, Wayfair cannot conjure a truly phantom clause to support its faulty claim. Wayfair was baselessly attempts to suggest that Jones disclosed Abel's text messages to Sloan before receiving a subpoena. Other than this conclusory allegation, Wayfair fails to allege what these purported text messages actually contained, when and how they were purportedly disclosed, how, if at all, they involved confidential information relating to Wayfair, or how messages that support Sloan's purported statements that Nathan could expect to be sued could be confidential information under the agreement. Instead, the amended counterclaims allege that Wayfair's co-defendant Nathan said that the Sloan had told Nathan that Sloan had seen the counterclaim conveniently employ passive voice here. Abel's that's actually a funny way to say it. I mean, her lawyers are exactly like Stehanie Jones. I feel very in-your-face brash. Like, I feel like exactly how they describe Stehanie Jones is exactly how her lawyers are, you know what I mean? Instead, the amended counterclaim alleged that Wayfair's co-defendant Nathan said that Sloan had told Nathan that Sloan had seen. The counterclaims conveniently employ passive voice here. Abel's unspecified text messages. Well, did they or did they not? Like, did you give it to them? This game of telephone is nothing more than hopeless speculation, not even purporting to involve Jones or Wayfair directly, cannot support the conclusion that Jones must have leaked confidential information about Wayfair to Sloan, nor suffice as a plausible basis for a legal claim. Wayfair also fails to tether any alleged disclosure to the language of the agreement. This is for good reasons. The agreement's confidentiality provision is narrow drawn. It obligates Jones' work only to use reasonable and diligent efforts to keep confidential information confidential, and it expressly permits disclosure to third parties to the extent necessary to fulfill its obligations under this agreement or to its legal representatives. Wayfair never alleges that any disclosure fell outside these limits. It does not contend that the information disclosed was not necessary to fulfill Jones' work's obligations, or that it was shred for a prohibited or illegal purpose, or that it was not already known to third parties. Nor does it allege that any information even qualified as confidential information as defined under the agreement, or that it was not excused per the agreement, which excludes form of definition of confidential information material, which is or later becomes publicly available through no wrongful act of company. Courts routinely dismiss breach of contract claims where, as here, the pleading fails to connect allegations of wrongdoing to the operative contract's actual terms. Wayfair's second breach of contract counterclaims, alleging that Jones and Jones' work somehow breached the agreement by failing to follow instructions, fares no better. This counterclaim offers no detail about what instructions were purportedly given, who gave them, when or what context, how Jones or Jones' work did not follow them, and how this constituted a breach of the agreement. Indeed, Wayfair does not point to a single provision in the agreement that required Jones' work to obey its instructions at all because no such obligation exists. In short, Wayfair's breach of contract counterclaims, even after amended, persist in being devoid of any factual allegations that would support a breach of any enforceable contractual duty. Courts routinely find that claims as these built on speculation, inference, and generalities alleging a breach not of the agreement, but of vague, ambiguous, and ever-shifting requirements not actually in the contract are not enough. Wayfair fails to plausibly allege any harm it suffered. Even if Wayfair had identified a breach of the agreement, which it has not, it still fails to allege any speculative damage resulting from that alleged breach. Are you kidding me? You're literally doing this after Wayfair has closed down? Oh, but they didn't suffer anything. Like, oh my gosh. Nowhere in the counterclaims does Wayfair allege any concrete harm stemming from the purported disclosure of unspecified confidential information, let alone the disclosure of any such information. They do not allege how any content was purportedly false, damaging, or even traceable to Jones or Jones' works. And Wayfair does not allege any actual consequence, financial, reputational, or otherwise, suffered by Wayfair as a result. Again, they keep saying a lawful subpoena. Even more telling is that Wayfair does not allege, it does not claim lost revenue, lost opportunities, increased costs, reputational decline tied to a specific event, or any identifiable economic or actual injury. C. The Speak Out Act bars enforcement on the confidentiality clause. Assuming arguendo the Wayfair has plausibly alleged a breach of the agreement's confidentiality provision, which it has not, including because there was a subpoena, its claims fails as a matter of law because enforcement of that provision is barred under the Speak Out Act 42. The act is designed not only to protect direct victims, but to ensure that witnesses, employees, and third parties are not contractually gagged from participating in investigations, complying with subpoenas, or exposing retaliatory conduct that seeks to chill lawful speech about abuse, can perpetrate illegal conduct by silencing those who are survivors of illegal sexual harassment and assault or illegal retaliation, or have knowledge of such conduct while shielding perpetrators and enabling them to continue their abuse. Yeah, but if the abuse isn't real, if the sexual harassment actually never took place and you knew that, Stehanie Jones, then this is not a fair argument. You're arguing, oh my God, like it actually happened, which still hasn't been proven yet. And I think that's what Freeman is about to say. What Wayfair seeks to do here is precisely what the statute prohibits: punish Jones and Jones Works for complying with legal process and bringing to light the extent of Baldoni's harassment of Lively and Wayfair's role in retaliating against Lively. Wayfair's amended counterclaims themselves establish that its dispute with plaintiffs arises from Baldoni's own misconduct on the set of It Ends With Us, including his sexual harassment of co-star Lively, conceding that during a period of intense public scrutiny, Wayfair faced press inquiries into Baldoni's behavior, including accusations that he fat-shamed Lively, kissed her too long during a scene, and acted inappropriately. These allegations were at the core of a reputational crisis, one Wayfair had tried to suppress. Now, this is what I highlighted it in green, okay? Very interesting the way she words this next paragraph. Wayfair does not deny that Baldoni was facing public scrutiny due to his mistreatment of women, nor does it deny Baldoni, Wayfair, Nathan, and Abel's smear campaign against Lively in the wake of such mistreatment. I'm pretty sure that they've denied all mistreatment against women and also against Blake Lively. That is why we are here today. To put this in here, I think is, again, It does not deny that the information that was ultimately reported in the press related to that scrutiny, mistreatment, and smear campaign. Angry not at Baldoni's gross mistreatment of Lively, but instead that it came to light. Wayfair seeks to punish Jones and Jones Works under the agreement's commercial confidentiality clause, claiming that Wayfair's misdeeds and retaliation should have never been disclosed. This effort to chill disclosure, shift blame, and distance itself from its own conduct and its co-founders' blatant harassment is repugnant and should be dismissed out of hand. I think you're repugnant. How about that? I can't believe she would say that. His treatment of Lively and women, oh my God, and that they haven't denied anything. We're literally here because they're countersuing because they deny all of it. D. Wayfair has not alleged a material breach excusing its own performance. Then it goes into that. I didn't highlight anything there because there's a lot. Wayfair's counterclaims for breach of the implied covenant of good faith and fair dealing must be dismissed as duplicative of its breach of contract claims. Wayfair's counterclaim for breach of the implied covenant of good faith and fair dealing is not an independent cause of action. It is a repackaged contract claim based on the same conduct and obligations already at issue in its breach of contract counterclaims. Under well-settled New York law, such duplicative claims are not permitted. That is precisely the case here. Wayfair's implied covenant claim is predicted on the same allegations, often verbatim, that underpin its breach of contract claims that Jones Works allegedly disclosed confidential information. The deficiency runs deeper than duplication. Wayfair does not ever actually allege that Jones Works acted in bad faith in performing the agreement. It alleges only that Jones Works breached it. Wayfair's sole conclusory allegation that Jones Works and Jones maliciously disclosed confidential information for the specific purpose of harming Wayfair and Baldoni does not alone support Wayfair's claim for breach of the implied covenant of good faith and fair dealing because, notwithstanding the allegations' dramatic flair, it does not allege some separate conduct that had the effect of destroying or injuring the right of the other party to receive the fruits of the contract. Indeed, the amended counterclaims contain no allegations showing that Jones or Jones Works did anything other than perform the agreement in good faith and reasonably until Wayfair's clears breach. Oh my gosh. Wayfair's defamation counterclaim must be dismissed. Wayfair's new defamation counterclaim, which is inherently subject given that it is based on alleged facts well known to Wayfair at the time of its original counterclaims, unsurprisingly also fails. To state a defamation claim, public figures like Wayfair must show that the statement complaints of were 1. Of and concerning the plaintiff, 2. Likely to be understood as defamatory by the ordinary person, 3. False, and 4. Published with actual malice, that is either knowledge of falsity or reckless disregard for the truth. Wayfarer's claim does not plausibly allege that the alleged statement was actually false or published with actual malice. The counterclaim must be dismissed. The alleged statement is constitutionally protected opinion. Courts have routinely found that this precise phrase, smear campaign, is a protected opinion. Wayfarer fails to allege that the plaintiffs made a false statement. Second, Wayfarer does not allege facts supporting a conclusion that the alleged statement was false. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. Wow, that was really broken of me to say. Second, Wayfarer does not allege facts supporting a conclusion that the alleged statement was false. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. When falsity is an element of a state of defamation claim, federal courts have required plaintiffs to plead facts that, if proven, would allow a reasonable person to consider the statement false. Here, Wayfarer alleges no facts as to how the alleged statements that Wayfarer had engineered a retaliatory smear campaign against Lively were false. I'm pretty sure all of their counterclaims make it a statement of that it was false. It's false information. Like, Wayfarer even admits that people in its circle held Lively in deep disdain and regarded her self-immolation with a degree of schadenfreude, which was the natural result of the Wayfarer party's first-hand knowledge of Lively's vicious behavior and malignant persona. This is interesting. So she's saying because they said that they didn't like her, okay, on top of knowing her vicious behavior, those two things taken together, those allegations made the core of the alleged statement. Wayfarer executed a coordinated media offensive to discredit Lively. But those things don't add up to a smear campaign. You could not like someone and know that they're a vicious person and still not run a smear campaign. So, like, you still haven't proved the fact that it actually is the truth. Like, 1 + 1 is 2. Where's the math? The math ain't adding. Just because they didn't like her and they knew that she was vicious doesn't mean that they actually executed a smear campaign. Hilarious. There was no smear campaign. Okay? Like, oh my gosh, it's so crazy. Even they say, like, it was a defense. It was a defense. They were defending themselves. They were counteracting what was coming in. Even by its own telling, Wayfarer marshaled Price's PR resources and harbored overt hostility towards Lively, all fully consistent with the alleged description to Sloan. Wayfarer fails to plead the plaintiffs acted with actual malice. First, Wayfarer sought public attention to influence public's opinion, including by acquiring the film rights to Hoover's best-selling novel Ends With Us, partnering with Sony, negotiating charitable giving provisions, casting its co-founder and well-known actor Baldoni opposite Lively, and engaging PR firms to broadcast its views to the public, positioning Wayfarer executives as thought leaders. So by them getting the rights to the film and partnering with Sony and giving 1% of its money, of its profit to No More, that made that they were doing all of that. They were doing everything they could so that they could cast Blake Lively so that they could sexually harass her. And no one would think anything of it because they're thought leaders. Give me a break. Oh my God. Second, Wayfarer voluntarily thrust itself into the public controversy by proactively engaging PR and crisis management firms. What did you want them to do? Just completely get destroyed? Look what has happened to them. Oh my God. Wayfarer also worked alongside Nathan and Abel to devise media strategies to counteract reputational threats, deliberately jumping into the media fray. Third, Wayfair has played and continues to play a prominent, non-trivial role in the controversy by financing, producing, and marketing the film. Do you want him to just give up the movie? Give up the movie? So what? So Blake Lively and Ryan Reynolds could have it? This ending is absolutely unhinged. Third, Wayfair has played and continues to play a prominent, non-trivial role in the controversy by financing, producing, and marketing the film, engaging multiple PR firms in connection with promoting the film, and Wayfair and its executives specifically having its founder direct and star in the film, negotiating publicity with Sony and Lively's team, and running the movie set on which Lively's mistreatment occurred. Fourth, Wayfair has substantial and ongoing access to effective channels of communications and hence has more realistic opportunity to counteract false statements than private individuals normally enjoy. Wayfair has employed multiple PR firms coordinated with Sony's global media team, devised strategies involving third-party surrogates, and fielded multiple press inquiries. Its counsel continues to appear on and be quoted in various media outlets, and even created a website specifically to disseminate information about the case. Yeah. Duh. Of course they're going to. What is the problem here? This is so crazy. What do you guys think? Because I think this is just unhinged. But obviously they completely dragged Stehanie Jones, so, Wayfair fails to allege actual malice. Wayfair's counterclaim fall far short. Wayfair's counterclaims fall far short of alleging actual malice. The pleadings are devoid of any allegation that Jones possessed contrary information, ignored known facts, or otherwise acted with the requisite subjective awareness of falsity or probable falsity, acting in defense of itself and bulldozing an implicit admission that a public campaign was underway. Plaintiffs are entitled to attorney fees under New York's anti-SLAPP law. Conclusions. For the foregoing reasons, plaintiffs respectfully request the court to dismiss Wayfair's counterclaims with prejudice. Of course I got that word wrong. For the ongoing reasons, the plaintiffs respectfully request the court to dismiss Wayfair's counterclaims with prejudice. Okay, so that was the first motion filed by Stehanie Jones. As you can tell, I done a little bit of a wardrobe because I just went to work and I'm back. Currently, right now, the Leafs are in overtime with the Florida Panthers 4-4, but I am here to finish this and go over the motions filed by Stehanie motherfucking Jones. So we are now going to get into the second memorandum that was filed today. Whew, what a day. Okay, so this memorandum was filed as well today, and it quotes, Plaintiff's memorandum of law in support of their motion to dismiss Jennifer Abel's amended counterclaims. So this is a memorandum that will just be about Jennifer Abel's amended counterclaims against Stehanie Jones. The other one that we read was the entire Wayfair's parties. This is Stehanie motherfucking Jones's response to Jennifer Abel's amended counterclaim. My gosh. And I'm not gonna lie, as I said before, she kind of does drag Jennifer Abel and make some good points. I mean, legally make some good points, but is it enough in the court? I'm not sure. As well as morally, I don't think it's right anyway, still morally, but legally speaking, we'll see what the judge has to say. Just in the opening statement, it says Jennifer Abel's counterclaims are a rotating game of whack-a-mole, where the minute one baseless theory is debunked, another even more implausible theory pops up in its place. In her amended counterclaims, Abel abandoned 6 of the misguided counterclaims she originally filed against Jones and Jones' works, including the fantastical story that she was falsely imprisoned by her former employer during her termination meeting. Instead, she now claims even more desperately that she was hacked by Jones' work acting as a spy. This new theory follows the familiar pattern and has an obvious purpose: to draw attention away from the text messages that she cannot and does not deny she wrote that form the basis of Jones's well-founded claims against her, for which she has no valuable defense. Those text messages conclusively corroborate that Abel brazenly conspired to steal Jones Works' clients and documents and trash her employer on the way out the door. She then goes to show a few of the text messages, which I'll zoom into, between Melissa Nathan and Jennifer Abel. One saying, "I know, and once you are gone, we will be on all account. I know, and once you are gone, we will be on accounts together and make really good money and be happy." Then she responds, "Let's just keep it steering that way, and you take this fucking client and never talk to her again, I swear to God." Like, as someone who's been in really toxic work environments, like, I don't know. I don't really see what she's stating here, as we'll get into, but they reveal that she made no effort to hide her malice against Jones Works or her plan to go to war with Jones Works and hold them hostage on her way out the door. There's more text messages here that I will zoom into where it says, "We are going to war, holding them hostage." Again, those are just like cherry-picked text messages without any context. Who knows who they're talking about? I don't know. And they uncover that. So then it goes, "They reveal that she made no effort to hide her malice against Jones Works or her plan to go to war with Jones Works and hold them hostage on her way out the door." And they uncover that. Unsatisfied with only stealing clients, she also set about to steal Jones Works' confidential documents, even boasting of her ability to evade the security measures the company took to stop her by using hundreds of different emails to infiltrate Jones Works systems. Indeed, her two-faced and scornful behavior was not reserved for Jones Works. Despite publicly hitching her wagon to Baldoni behind his back, she was trashing him too. They really throw Jennifer Abel under the bus here. There's some cherry-picked text messages again that say, "From Jennifer Abel to Annalisa Jessup." Yes, pretty much. I have my way around that shit because I have like hundreds of different emails for each domain that I owe. She can suck it. Again, not even knowing if this is about Jones or not. I mean, there's no little context to any of these messages, but again, it doesn't look good for Jennifer Abel. I'll just say that. "I can't stand him." And then it goes into messages that they put already in Blake's CRD complaint. They've already leaked these messages of Jennifer Abel and Melissa Nathan talking poorly about Justin Baldoni. "I can't stand him. He's so pompous. A men's retreat during release. Is he crazy? And being off the grid for that summer because he's just so overwhelmed. Like, calm down. You're not that important and nobody gives a shit how hard your life is." It's so cringy. They go on to show a couple more text messages as well. His face. Blake was probably grossed out too. Yeah, and filed a cease and desist. So those are messages between Jennifer Abel and Melissa Nathan. And it goes on to say, even her co-conspirators Nathan could not accept, even her co-conspirator Nathan could not escape Jennifer Abel's treachery. And then it shows some text messages of Jennifer Abel actually talking about Melissa Nathan, saying that she talks from both sides of her mouth. So I don't know. I don't know about these text messages because, again, there's no context to them, but they're here, so thought we would read them. Abel's amended counterclaims are only the latest episode in this unbroken chain of fantasy in her quest to rewrite history. But her newest story suffers from the same fundamental flaw as her last. It is not true, and it cannot, in any event, support the newly invented counterclaims she asserts. Each and every one of those counterclaims should be dismissed with prejudice. First, her effort to convert the entirely routine practice of her employer, recovering the phone it had provided to her during her employment, into a smorgasbord of hacking claims fails. The fact is that Jones Works produced documents recovered from the iPhone in response to a lawful subpoena, which even Abel now accepts. So they're going back to this legal subpoena, this lawful subpoena, but the truth is from that subpoena, once again, Jones, you didn't have to give everything. And how did they know to only ask for that one device? I mean, when you really break down this lawful subpoena from this sham lawsuit, hello, it's not actually legal when you think about it. Like, you could have done so many different steps to not have to produce that, like inform Wayfair, like go to the courts and fight it, like, there were so many other options than just, here you go, of course, take it. I mean, how did they even know to ask for that? That is the thing. And they asked for it all the way from December of 2022 when Blake signed on to the film. How would they know? It's like, when you really piece it together, you can play this little role, but I mean, come on, okay? Which even now Abel accepts. In any event, Abel herself admits that the phone itself belonged to Jonesworks, that she returned it voluntarily, and she provided Jonesworks with the passcode to access it. Even Abel's own allegations prove that Jonesworks didn't and couldn't have hacked anything. The very circumstances that Abel pleads doom her claims from the outset. Any hypothetical access using credentials Abel voluntarily provided cannot, as a matter of fact, be unauthorized. Second, the torts Abel alleges also fails. Not only does New York not even recognize the privacy-based torts Abel tries to allege, but no court anywhere has espoused the theory that Abel advances, that she somehow had a legally recognized reasonable expectation of privacy against her employer in work-related communications made on a company-owned phone. Simply put, Abel had no right to privately use her company phone to undermine and hide things from her employer, including a secret business for her own benefit against her employer's interest, and seek to harm her employer's public reputation and private business interests. And Jonesworks did nothing wrong in retrieving that phone when it fired Abel and later producing documents in response to a subpoena, which revealed in Abel's own words in black and white, in text after text, the clear evidence of outrageous misconduct that Abel now stands accused of. For the same reason Abel's false light claims similarly cannot stick. Abel may wish that the world did not know about her unethical and unlawful acts, but the light that Abel has been cast in is unavoidably true. Lastly, the remainder of Abel's claims are equally infirm. Abel had no property interest in the phone number that she now claims Jonesworks somehow converted. Any specific acts that alleged distressed her and could plausibly meet the extraordinarily high bar required to sustain a claim for infliction of emotional distress. So they're pretty much saying that they don't think that this caused any emotional distress, and it doesn't fall under emotional distress, and Jones is not liable for that. Having been called to account for her actions and having no viable defense, Abel has turned to defense by smokescreen. None of her round 2 counterclaims have legal merit, and the court should dismiss them in their entirety and with prejudice. Factual background, then they go into some background, how Abel worked there since 2020. Abel elected, they're saying that she volunteered to have her number transferred to a work phone. Through her contract, Abel willingly agreed that any dispute she might have with Jonesworks would be decided under New York law. Abel also agreed to standard terms commensurate with her position, including that she not steal or divulge the company's trade secrets, not compete with Jonesworks while working for the company, or for 6 months after leaving. That's interesting. And not try to poach Jonesworks' clients or employees. Abel expressly agreed that these covenants were reasonable. Abel's counterclaims are laden with histrionic complaints about all aspects of her employment at Jonesworks that are both irrelevant and unsupported by reality. In the green here, just another mistake, which I don't think there should be any spelling mistakes, but it says never voicing he concerns. It's supposed to be the concerns, regardless. Only further confirming her optimistic effort to rewrite history and shift her narrative when the facts are no longer convenient, she excised from her amended counterclaims her previously pled admissions that she thought highly of Jones up to the time of her prospective departure. Then they show a text message that she sent with, where it's just saying, I'm very grateful for the opportunities, Of course someone's going to say that to their employer, whether they liked it or not. I mean, that is just so crazy. Of course you're going to say that, you know? Like, thanks for the opportunity. I had a good time. Bye. In July 2024, Abel informed Jones of her intent to leave Jones Works. But in mid-August 2024, Jones Works learned, after inquiring into suspicious file transfers on its computer systems, that Abel had been downloading dozens of proprietary documents from the company's systems to her personal laptop, which she had no reason or authorization to access, let alone serendipitously misappropriate. Jones Works swiftly responded and on August 21st, 2024, with counsel, terminated Abel, which she did, including falsely sign a statement that she had not retained any Jones Works documents, despite plain forensic evidence provided that she had been emailing documents to herself weeks before termination. If they can prove this, it's not looking good. I mean, they don't give anything in here. These are just claims, which they don't have to do, but I mean, I don't think it's enough for either of them to get dismissed, but I mean, if this is true, it does not look good for Jennifer Abel. Once again, to skirt accountability for her decisions, Abel incoherently and fantastically characterizes that this attorney asking her to sign termination paperwork as coercion and threats that allegedly placed her under extreme duress, and tries to disavow the consequences of her voluntary compliance and signature on documents. Text messages downloaded to Abel's company phone revealed that Abel had been spearheading a campaign to retaliate against Lively for allegations of sexual harassment against Baldoni, and also instigated a campaign of destruction and disparagement against Jones herself. We have yet to see any text messages that prove this claim. Legal filings were produced pursuant to a lawful subpoena. They probably say that dozens of times within both of these motions. Furthermore, despite baseless hypotheticals that Jones Works could access her personal communications, Abel identifies no personal information whatsoever that was allegedly revealed in violation of any conceivable privacy rights. Instead, she complains that text messages revealed her misconduct in participating in an unlawful retaliation campaign during her employment, but behind the back of her employer. Okay, I still have yet to see any text messages that prove a smear campaign yet. Can someone fill me in, please, that proves it? Legal standard. To survive a motion to dismiss, a complaint must state sufficient facts accepted as true to state a claim to relief that is plausible on its face. They're basically saying that she hasn't claimed any of that so far. The argument is number one. Abel's hacking claims fail because she makes no plausible factual allegations that Jones Works hacked anything. Then they go into some laws that say what hacking is or isn't. Undeterred by the plain purposes of these statutes, Abel brings a multitude of vague, contradictory, and inapplicable claims seeking to apply hacking statutes to the unremarkable reality of an employer recovering work texts from a work phone. Each claim suffers from fundamental defects that require its dismissal. Abel's implausible and vague allegations fail Rule 8 standards. Abel's allegations of hacking are wholly vague and conclusory, and fail even the most relevant Rule 8 standards as a matter of law. For example, Abel alleges in wholly conclusory and unsupported fashion that Jones Works bypassed the password protection on her accounts. How? Using what technological terms? In what circumstances? She similarly alleges that Jones Works was monitoring and intercepted her private communications in real time. But again, how? When? Which communications? And what is her basis for believing or alleging this? This wholly conclusory assertions are utterly devoid of any factual corroboration or grounding as required by Rule 8, and based on what she observed or otherwise supported facts. I think that they have people talking to the Wayfair parties because in their response, they said on belief and knowledge or something to that effect, meaning that they know for sure, they have evidence proving to that. So I think there is going to be proof to show, because why would they put that in there if they didn't have any it just doesn't make sense. And Brian Freeman, I don't think, would play a long game of lies like the Lively Party has done. In a similar vein, Abel conclusorily alleges that Jones Works accessed protected computers knowingly and without authorization or consent, or in a manner that exceeded their authorization. This again is a conclusion of law and recitation of a statutory element, not an alleged factual basis for her claim. And further, which is it? And how did the company that owned the phone lack authorization to use it? And how did Jones Works allegedly overcome generally applicable rules regarding access to those computers? What even were those rules, and how could Jones Works possibly overcome rules simply by using a passcode that Abel admits she provided to it? So Stehanie Jones is playing real dumb here, and all of the things being like, well, I didn't know there was any rules to that. I didn't know there was a law stating that I couldn't go through someone's phone. It was a company phone. Come on. Abel's allegations of harm are equally conclusory and often incoherent. She alleges that she suffered enormous harm to her personal and professional life. Abel must make factual, non-conclusory allegations stating a plausible claim, and defendant's conduct caused specific harm. To the extent Abel alleges any conduct by Jones Works at all, those alleged acts did not violate any of the alleged statutes. Abel also fails to plausibly allege that Jones Works engaged in a specific conduct prohibited or required by the applicable statutes to state a claim. I'm not sure why I can't say that word tonight, but I've been talking and working all night, so... Indeed, courts have flatly rejected the theories of liability attempted here. So they're basically saying next that, the phone by the CFAA requires that a person use illicit means to circumvent some gate controlling, and they're saying that that is not what they did here, that it was perfectly fine that the employee asserted claims under the SCA Wiretap Act and Section 502, all of which the courts rejected. So then they bring up other cases that are very similar to this one when it comes to Jones versus Abel, or Abel versus Jones, and the courts rejected them. Therefore, they should reject and dismiss Stehanie Jones. With respect to the Wiretap Act, the court concluded that the text messages appeared on his company iPhone as a result of the employee's act of syncing his new iPhone to his Apple account without first unlinking his company iPhone. So the employer did not intentionally capture or redirect the employee's text messages to the company iPhone and thus did not intercept them. And there it says that trial, they rejected that claim that the employee filed, therefore this claim should be the same. The employee's Section 502 claim also failed that the employee's fact-barren and vague allegations, which closely resemble Abel's allegations, are precisely the type of threadbare recitals proscribed by Twombly and Iqbal. And then that's another example. Abel makes the same vague, conclusory, and insufficient allegations as the Sunbelt plaintiff, and those allegations should meet the same end: dismissal. Abel's claims fail numerous additional statutory requirements. Abel's alleged harms are not cognizable under the CFAA. Messages on the iPhone are not in electronic storage under the SCA. The SCA only prohibits obtaining communications while they are in electronic storage in a facility through which an electronic communication service is provided. So basically they're saying the cloud or the iPhone storage device, Google Drive, or wherever they're claiming that Abel's phone was storing, that doesn't fall barren. That's kind of like it just doesn't work, right? It has to be actually on a device. So she's saying because it was in electronic storage, it doesn't actually count. It's an interesting defense for sure. Abel alleges no plausible intent to defraud. Abel alleges Jones Works' conduct constitutes a knowing intent to defraud Abel in her personal data and thereby derive financial gain. Jones Works accessed data in order to devise and execute a scheme and artifice to defraud. These threadbare, and conclusory allegations fail on their face. They also independently fail because they lack particularity in alleging the claimed fraud. And they fail a third time because the amended counterclaims allege that Jones Works used the communications to help Lively, a gratuitous allegation that has nothing to do with fraud or able or financial gain. Come on. Oh, y'all are just like Stehanie Jones, Leslie Sloan, and Blake Lively, I swear, are all apples from the same tree, okay? Able does not plausibly allege any jurisdictional nexus to California. Abel's Section 502 claim fails at the threshold because despite repeated absurd allegations about Jones Works accessing data, the iCloud and email accounts, she alleges no nexus between those made up facts and California. So if it's not this reason, it's this reason. If it's not this reason, it's this reason. I mean, she's just saying there are so many things like, yeah, she did it, but it is, you can't sue me for that because how was I supposed to know? And it doesn't really fall under any law. Abel's jumbled statutory copy and paste fails under Section 502. To plead as broadly and vaguely as possible, Abel copies and pastes miscellaneous words from Section 502 alleging that Jones Works violated the statute by knowingly and without permission accessing and causing to be accessed, taking and causing to be taken, copying and causing to be copied, using and causing to be used computer services. This comprises nothing more than a jumbled recitation of words taken from different subsections of Section 502 with no seeming rationale. Abel fails to plausibly allege that Jones Works intercepted any messages. So then she's basically saying, well, if you think that I was on your iCloud, prove it. Which ones? You didn't say anything. You did not prove that I intercepted any messages. Abel's tort claims must be dismissed. Abel cannot claim invasion of privacy based on work text on a work phone. Abel's invasion of privacy claims, counterclaims 5 and 6, fail on their face. New York does not recognize common law privacy tort claims, including specifically the two claims Abel brings here: intrusion upon seclusion and false light. In New York, the right to privacy is governed exclusively by Section 50 and 51 of the Civil Rights Law. We have no common law of privacy. Even under California law, Abel's claims fall short. First, Abel admits that she voluntarily transferred her phone number to Jones Works upon hiring, and that her newly issued device with that phone number was a company-owned and controlled iPhone. As a matter of well-settled law, Abel enjoyed no reasonable expectation of privacy in the contents of that company phone. No invasion of privacy claims because an employee could not legitimately claim an expectation of privacy in a company-owned phone. Abel's conclusory allegations that she had a reasonable expectation of privacy is of no moment because she had no such expectation in a work phone. That's kind of interesting because Jennifer Abel states that it's common in her practice to have your personal phone and your work phone together, and that they made an agreement to bring the phone number over and da-da-da-da-da. So, I mean, it's just getting a little bit messy, and I think it's really going to come down to the judge and what he thinks. I honestly think everyone could file as many memorandums as possible to get dismissed, like every single Lively party has done. And I don't think, honestly, until we get into discovery and until depositions are well underway, should the judge grant anybody room for dismissal, because they're all guilty. Do you know what I'm saying? And we need to know how far down the guilt goes and who is involved, you know? Second, Abel fails to allege that Jones Works acted in any way that was highly offensive invasion of that privacy or an ingracious breach of social norms. I think they did, I mean, maybe not prove it, but they definitely mentioned it, that you went through her phone. I mean, what? The vast majority of Abel's newly fabricated allegations are nothing more than conclusory speculation that this court should disregard. Abel's allegations that Jones Works could read her communications with her fiancé, parents, friends, everyone, notably does not allege any facts because there were none to support a conclusion that it ever did. So I find that very interesting that, I just think Jennifer Abel and the Wayfair parties and Brian Freeman can prove it, or they wouldn't have never put that in the amended complaint, in my opinion, but we'll see. She does make a good point that they allege that they could read her communications, but did she? That's where we need to know, and that's where I feel like they have some witnesses on their side. But again, we won't know until the time comes for us to know. Likewise, Abel's bald allegation that Jones Works had been intercepting and monitoring all of her text exchanges lacks any specificity or perpetuated basis that could tip it into plausibility, including by not identifying a single supposedly monitored or intercepted message. Again, none of what she alleges is Abel's personal information, nor does it rise anywhere near the level of highly offensive or egregious that would meet the required standard. So they go in to say what that standard is, and Stehanie Jones isn't really denying that she did anything, but she's kind of saying okay, well, prove it, right? Third, Abel's false light claim fails because she does not allege any false or misleading disclosures. A false light claim that rests on the false nature of the publication is substantively equivalent to a libel claim based on the same publication. Abel's complaint appears to be not anything false was said about her, but rather that Jones Works allegedly revealed Abel's own words to Sloan and Lively. Far from portraying her in a false light, the publication of her own text messages in her own words has painted her in the truth. Her privacy counterclaims should be dismissed. Jones Works cannot convert something Abel never owned and voluntarily transferred. But Abel's claim stumbles at the starting gate. She alleges that she owns and or has a possessory interest in the phone number. Then they put the phone number. Courts have consistently held that telephone users do not have a property interest in their phone numbers. That's a good fight. I'm not going to lie, that's a pretty good argument. Abel's claim fails to meet the other two elements as well. Abel admits that she voluntarily transferred the phone number to a phone owned by Jones Works and to Jones Works' phone plan. Even crediting Abel's allegation, she nowhere offers any plausible basis to conclude that Jones Works retaining the phone number and she had transferred was conversion. Abel also offered nothing but the most conclusory and thus insufficient allegations that she vaguely suffered damages. Failing every element, this claim should be dismissed. Abel's distress, if any, arises from being caught red-handed and does not give rise to tort claims. Abel's emotional distress claims are equally deficient because they fail to allege the required elements of severe emotional distress and extreme and outrageous conduct. Abel fails to allege legally cognizable severe emotional distress. What I think is so crazy here is now they're going to go in to explain what emotional distress looks like, and they're saying that Jennifer Abel doesn't have any of those symptoms, so then she can't claim it. It's just so bizarre, okay? Severe emotional distress means emotional distress of such substantial quality or enduring quality that no reasonable person in civilized society should be expected to endure it. Instances where courts have found this lofty standard to be adequately met include, for example, a plaintiff suffering anxiety, chest tightness, heart palpitations, panic attacks, depression, insomnia, and being diagnosed with post-traumatic stress disorder. Don't you think having her whole life turned upside down does not meet these standards, Stehanie Jones? Are you crazy? So you can treat your staff and do whatever you want to your staff, but as long as they're not having heart friggin' palpitations, everything is fine. Abel's rambling allegations, albeit hyperbolic, cannot meet this standard. She complains of certain alleged working conditions at Jones Works, including Jones calling at late hours and reprimanding Abel in front of other employees. despite conceding that she remained working there for more than 4 years. She complains of being abruptly terminated by Jones Works and that the manner of her termination, concededly being asked to meet in a conference room with employment counsel and Jones Works' chief of staff, sign paperwork and leave, caused her to disassociate and fall into a state of shock. And she complains of the inconvenience of losing access to her mobile phone number as well as certain accounts and contacts for a short time. I don't care how long you stay at a place of employment. It does not mean that that place is not toxic and that the boss is not completely an unhinged monster from hell. Okay, I once stayed at a place of employment for years because financially I couldn't leave and I wasn't strong enough to leave yet. But let me tell you, it caused me a lot of damage, okay? So this, Jones, I think this is probably your weakest argument yet. Worry, anxiety, upset, stomach concern, and agitations are not severe emotional distress. Abel alleges no extreme or outrageous conduct. What? Anyway, Abel does not allege any such extreme and outrageous conduct that would be sufficient to meet this threshold. Indeed, she does not allege any specific identifiable conduct in support of this claim at all. Instead, she only vaguely invokes the misconduct of Jones and Jones Works and its officers, directors, employees, and agents. She literally states in there how you went to a psychic, went back to the office, and Stehanie Jones told the entire office about Jennifer Abel having a drinking and a gambling problem, as well as being pregnant with twins, when Stehanie Jones knew fully that Jennifer Abel was having fertility issues. Like, she does say very clearly misconduct by Stehanie Jones. So for her to say at all in bold letters to me, wow. Even the supposed misconduct that Abel does allege does not approach the required threshold. Her allegations at most describe her after the fact discomfort with Jones's management style, under which Abel worked for 4 years, reaping ever increasing rewards. Abel's nonsensical allegations that Jones Works counsel asking her to sign documents was coercion and threats cannot save this claim. Abel's negligent-based claims fails because she alleges no negligence nor specific breach of duty. Again, Abel superficially recites the elements of this claim but makes no specific allegations of what conduct by Jones or Jones Works allegedly breached any duty owned by them as her employers and how. Much less does she allege any breach that either unreasonably endangered her physical safety or caused her to fear for her physical safety. Further, a claim for negligent infliction cannot be premised on intentional conduct, yet that is what Abel alleges. Jones and Jones Works intended to cause Abel emotional distress. Abel's undisciplined throw everything at the wall approach should not be permitted. She has failed to specifically plead any required element of intentional infliction of emotional distress and a hand-waving claim of negligence. Irreconcilable with intent cannot mask her failure. These claims should be dismissed. Abel's fraud claim fails in every possible way. A claim for a promissory fraud requires 1. A material false promise. 2. Made with knowledge of its falsity. 3. An intent to defraud or deceive. 4. That plaintiffs reasonably relied upon. 5. Causing damages. Wow. Once again, Abel fabricates a new set of facts in her desperation to save counterclaim 10 and still fails. Abandoning her original allegation that Jones Works supposedly induced her to port her phone number to a Jones Works phone in 2020 by promising her in 2024 that she would retain possession of the actual phone number. Abel now alleges that Jones Works fraudulently induced her to return its property when its chief of staff promised Abel that she still gave up her Jones Works issue iPhone and provided her passcode. Jones Works would release her number. Jennifer Abel literally has messages with the chief of staff, and he was saying that we will release your phone number upon your leave. So I don't know why she's saying that didn't happen. I mean, we saw the text messages, but that phone number belonged to Jones Works. And Abel had no right to withhold it, nor Jones Works any reason to need to induce her to return it. Put another way, Abel alleges that she declined to steal Jones Works' property by refusing to return it on request. Deciding not to commit a crime is not legally cognizable reliance. So they're saying that the phone belonged to Jones Works. Therefore, if Jennifer Abel hadn't returned the phone, that she would be stealing Jones Works' property. Are we being serious? Abel also must, but has not, set out specific facts in her complaint demonstrating that defendants never intended to make good on any of the promises made. Instead, she generically alleges that Jones Works never intended to perform the promise. Such vague conclusions are insufficient. Finally, Abel's generic claim that she was harmed is insufficient for lacking any nexus between defendants' alleged misrepresentations and her losses. A plaintiff must have suffered consequential damages caused by the actions the plaintiff took in reliance on the defendant's misrepresentations. Abel's overreaching fraud claim should be dismissed. Conclusion. For the foregoing reasons, plaintiffs respectfully request that the court dismiss Abel's amended counterclaims in their entirety with prejudice. Damn. Okay, guys, so I know that was a lot, but 2 memorandums plus all the stuff happening, OMG. And now I just found out that Taylor Swift has officially been subpoenaed. Taylor Swift's team came out with a statement saying she had nothing to do with the movie. She was not there. She had nothing to do with it. She was never on set. She doesn't know what's going on. She doesn't know why she's being subpoenaed, etc., etc., etc. We'll get into that quickly in another video. It will be super quick, unlike this one. But I just want to say thank you so much. Again, I'm so sorry about my sound. I ordered new cables and stuff, so those should be coming in. Then I had to stop the video, go to work, come back, make the video. My gosh, what a day. But I'm so happy you're here, and honestly, I'm just going to leave you with the same message that we've been going over is like, just show up, okay? Just do it. Just show up. You don't have to be perfect to start. I mean, this is a testament, honestly, right now, because I was so stressed today when none of my equipment was working. My mic broke, all of this stuff, but I promised myself that I would show up here 3 times a week, Monday, Wednesdays, and Fridays, and deliver all of the goods. So it was important for me to just like show up regardless of the perfection and the microphone and everything not working. It's obviously not the way I want to do it as someone who, you know, is striving to move forward and grow on this channel. Not having my mic set up was definitely a downer, but just the idea that I got this done and I was able to give the information and still show up. I mean, there's just power in that, and there is power in just showing up for yourself regardless of it needing to be perfect or you needed to be perfect. There is no right time, and I think it just really does build and build and build on that foundation of choosing you every day till you win and keep showing up. So I hope you are going to have an amazing weekend. Again, happy Friday. Yeah, I don't know. Let me know what you guys think about all of this. I think Stehanie Jones is as guilty comes. I think for me personally, she is one of the monsters that is directly involved in starting this huge fire and getting these lawsuits going. I think she could have put up a fight when she received the subpoena because the lawsuit was a sham. The lawsuit had nothing to do with her. She was never a client of Ryan Reynolds or Blake Lively. She could have done so many things in order to, one, fight the lawsuit, let the Wayfarer people know, etc., etc., and she did nothing. I think her, Leslie Sloan, and Blake Lively can all take a train now, buy your ticket, and go straight into oblivion because I'm done with you. But the things that she does say here about Jennifer Abel, if Jennifer Abel was like stealing information and doing that and that and that, and Stehanie Jones knew, but I mean, I don't know. I guess it's all going to come out, you know, eventually. So that's just the memorandums. But yeah, drop your comments. Let me know what you think. And thank you so much for being here. Hopefully come Monday everything is fixed, the system's fixed, and we can get back to normal. I should have cables and wires coming tomorrow, so oh my gosh. Anyway, thank you so much. Like always, I love you. I love you for being here, and I hope you have the most amazing weekend. Truly, from the bottom of my heart, thank you. Bye.